Good morning. Happy Memorial Day weekend, everybody. I'm sure that everybody's going to remember the actual purpose of this weekend and not just use it to barbecue and things like that. So, first thing we're going to deal with is hey, quit it. The first thing that we're going to deal with is a Freeman issue. Freeman has been pumping this particular story out. More CPS abuse with help from St. Luke's Health, Idaho, Meridian Police, and more. So Freeman's theory is that there is a giant conspiracy to take this baby here from these two young folks. And I want to give everybody just a little bit of background on my legal chops in this field. I have represented mothers, fathers, and non-parents in dependency proceedings. I have never once represented the state. I do not work for the state. I don't support the state. I'm not a fan of the state. And I don't, as a lawyer, I don't represent the state ever. I have never represented the state. In the dependency proceedings I've been a part of, that's a dependency proceeding or a termination of parental rights proceeding. Those are both proceedings where the state can take away the children from the parent. They're very somber experiences. No one takes them lightly. The parents are entitled to public defenders if they can't afford their own counsel. There are a lot of protections in place to prevent the state from stealing a child from you. It is not done lightly. They are appealed regularly. They're fought over tooth and nail. But I have never once, unfortunately or fortunately, ever seen a CPS case get to the point where they're taking the kids away where there wasn't something to it, where there wasn't at least indicators that something was wrong. Now, that doesn't mean that every time the children are taken away permanently. Again, the state will give you multiple chances. I mean, we could just look at Kate Peters' story, where she was apparently a drunk drug addict who was unable to take care of herself, let alone her kids, and the state still returned two of her kids to her. I mean, this is not something that the state takes lightly. So the theory that Freeman presents, that not only is it the police colluding with CPS, not only is it the judge colluding with the police and CPS, but that it's a private hospital that is colluding with the police and CPS and the judge to take away this child. For some reason, out of the blue, they want to take this specific child away, and the parents didn't do nothing, and there's no reason, and they're good people and blah blah blah, and there's no indication of anything wrong. Well, that's a bit of a bridge too far, and they hype this up as the most well-documented case in history, except the documentation is somewhat suspect. And things like this right here, this is a good indicator that you're being told what they want you to hear and not the whole truth. There's a lot of stuff in here, as you can see, that is blurred out. This is from St. Luke's. This probably contains a lot of the justification for the findings that St. Luke's made, and we don't get to see it. All they let you see here is that, oh, there's a large crowd outside who are protesting this. The crowd shouldn't have known about it. I mean, the state cannot publicize these things. So, St. Luke's felt that it would be in the best interest in the health and safety and welfare of the foster parents who were going to be taking care of the baby during the legal proceedings, it would be helpful if they were transferred out somewhere else for further care. Now, where this guy screwed up, where this is the grandfather who's obviously a biased party in this, where he screwed up is right here. It might be hard to see it, but somewhere in here, right here, impression, other, dehydration. If a baby is dehydrated, I'm not a doctor. I don't even play one on TV, but my best guess, if a baby is dehydrated, there's a problem. Wow, we can't even read it. Well, I don't know what to do for you here, buddy. I don't know how to here. Let's see if we can't. It's a picture, so it doesn't zoom well. That's the best I could give you. Right here it says impression. So system global, symptoms transport only, impression, other, dehydration. So if a baby's dehydrated, that is a huge problem. That is a huge problem. And for whatever reason, mom didn't take the kid to the appointment in the morning. We are told that it was just a routine checkup, but she didn't take the baby to the routine checkup. Let's just assume, arguendo, that was the case. But then she felt better in the afternoon, and she decided to go out and hang out with family. Baby could also be sick. Yeah, the baby apparently, allegedly, and I'm going to just go ahead with it, had a condition that caused it to vomit a lot. That's what they allege. But if a baby is dehydrated, that is a problem. That is a problem. And if you're not taking a baby who is dehydrated to the doctor so that the baby can be treated for the dehydration, that is a huge problem. That is a huge problem. And one other thing that he talks about in this is he goes on a big deal about there are four. Let's see. There are four pictures of. I don't remember exactly where it is, and now I've zoomed in way too far. There are four pictures of the child's hands. Here we go. Most troubling are the pricks on his hands, which show he's been jabbed at least 4 times. They claim it was only for the IV, but it makes no sense to have 4 jabs for a simple IV. Well, from my understanding, and again, I'm not a doctor and I don't even play one on TV, but when you're dehydrated, it makes it harder to get into veins. That's my understanding of reading medical reports, but not being a doctor. And IVs are great ways to get babies rehydrated quickly. So, uh, all told, in this case, where the baby was kidnapped, and there's this huge conspiracy to take this baby away from the kid. Let me remind everybody that number one, a judge who doesn't have a dog in this fight looked at the evidence and justified the taking, at least for a short period of time. And the same legal system, the exact same legal system that took the baby away, restored the baby to the parents at the end of it. At the end of it, they got the baby back. Now, if this is a huge conspiracy that involves the government, involves the legal system, involves everybody that is trying to take this baby away, why did the parents get the baby back? Nothing makes sense. Nothing makes sense. What does make sense is that the baby was dehydrated. What does make sense that they did not take the baby to the doctor visit. What does make sense is that out of concern for the baby, the hospital, the physician, whoever, made a call to CPS because and I would bet you, I mean, I'm not going to tell you that this is a true case, but I'm going to bet you that the parents, this wasn't the first appointment they missed. I'm going to make a bet because, I mean, how many parents of children have missed a doctor's appointment? And yet CPS doesn't get called on all of them. So nothing makes sense. Big red flags are when they give you some, but not all of the medical records, just the parts they want you to see. I mean, none of this makes sense. And the only way this would make sense is if you already believe that the government is corrupt and that the government is trying to take your babies. Well, the government is corrupt. That is true. But there is no industry. The physician from St. Luke's, they don't get paid a penny more or a penny less to make the diagnosis that they made. The EMTs don't get paid a penny more or a penny less not to do whatever. The cops, their pay is not dependent upon taking children away from parents. CPS, these people get paid salary. They don't make money to take babies away from kids or babies away from people. None of it makes sense. Place in an IV in an infant can be, yeah, well, but again, like, there is dehydration there. There's dehydration, and I'm assuming that's going to make it even harder. So all of this was nonsense, and I apologize for dragging everybody into it. Some other auditor or auditor adjacent person, their husband or something like that, was apparently just accused of being a. Anyway, kids were taken away, and again, it's the auditor or auditor adjacent gal had always had issues with CPS, and now maybe we understand why in that case, and that just brought up this case, and so I figured I would address it since I had a opportunity to look at it. And by the way, all the legal determinations that this guy makes are absolutely silly and inane. So just know that every single legal conclusion that he draws was wrong. All right, now what you all actually came here today to deal with. We're going to deal with a little bit of Chille de Castro. So this is the de Castro versus Wagner. This is the Lawrence County, Ironton, City of Ironton case. If you'll remember, Chille filed a protective order. He included all of the discovery requests that had been withdrawn, i.e. that were no longer pending, in his request for a protective order. And but yet still asked for a protective order on the discovery questions that he did not produce. So this is going to be Lawrence County's response to it. Lawrence County is the one who withdrew their discovery. And so I'm not going to go through this entirely because a lot of this is repeated in the second one. But yes, discovery is relevant, non-privileged information. I think it's a little, so relevant, non-privileged information is a fine portion, but it has to be, it's either relevant or likely to lead to admissible evidence, like reasonably calculated to lead to admissible evidence. So, for example, your tax return, if you're claiming loss of income as part of your damages, your tax return isn't going to necessarily be relevant, but it might lead to admissible evidence. Like your tax return might show that you made this much money last year and now you make this much money this year. How much money you made last year isn't necessarily relevant, but the difference between the two is. Or if you're claiming monetary damages for loss of income, then a social security number might help so that they could verify your employment and things like that, because that's likely to lead to relevant evidence, relevant admissible evidence. And Federal Rules of Procedure permits a party from whom discovery sought is to move for a protective order. The court can issue orders to protect a person from annoyance, etc. The moving party bears the burden, which I don't think that he did, except for the fact, again, my analysis of the previous thing is I think the court is going to fashion some sort of an order that is going to prevent Chille from having to respond to discovery until after the Rule 26F discovery plan is put in place. But not having seen the actual questions that are still pending that Chille is seeking a protective order from, I can't tell you which way any of those is going to go. So vague and conclusory allegations of confidentiality are insufficient. Are you going to come over here for a reason, Bok? The movement must make a particularized showing that the information sought is confidential. I don't know why they're making, excuse me, I don't know why they're making this particular argument, because they've withdrawn their discovery. And then defendant's first written discovery is no longer pending. Welcome to the Chicken Channel. So a court may not adjudicate disputes that have become moot. It's been withdrawn. I'm not sure that Chille was seeking discovery protection against Lawrence County, because, again, it was withdrawn. He just used them for some reason as his exhibit. It didn't make a lot of sense to me now, or then. It doesn't make a lot of sense now, but whatever. In this case, email correspondence between undersigned counsel and plaintiff on or about March 8th, 2023 establishes a written discovery request sent to plaintiff are no longer pending. Specifically, the undersigned counsel told plaintiff to disregard the first set of written discovery that was sent, because it will be sent again when the Rule 26F report is filed. Therefore, it should be denied. And then there's local rules. I wasn't aware of these local rules. I didn't look them up because it didn't really matter to me, because I don't get paid to look them up for this case. But there are specific local rules in the Southern District of Ohio. So it seems like most courts are going to have local rules about discovery, because discovery disputes are really, really fucking annoying for judges, because they're, generally speaking, petty. Just give them the fucking information. Don't ask stupid fucking questions. Let's just get to the point where you guys can either settle this or go to trial, generally speaking. So that said, there are local rules in this particular one, and the local rules require you to do things like meet and confer, and you have to exhaust all extrajudicial means for resolving their differences. After extrajudicial means for the resolution of differences about a discovery has been exhausted, in lieu of immediately file a motion, you may, not mandatory, you may seek an informal telephone conference with the judge assigned to supervise discovery in the case. So they're really trying to keep you. They're like, look, just talk to the judge. The judge is going to tell you, like, dude, just answer the question, or dude, you can't ask that question. The judge will do that. Like, just let's not make a mountain out of this molehill. And Section D of Judge Barrett's standing order provides the following regarding discovery motion. So this judge has taken it even a step further, and he requires counsel to try to resolve the matter both in writing and telephonically. If counsel are unable to resolve the dispute between themselves, then they must, this makes it mandatory, contact the courtroom deputy, Krista Zeller, and a telephone conference with all counsel, and the court will be scheduled as soon as possible. So again, he's like, look, I don't want to deal with the discovery motion. You idiots. Let's just resolve this. You get your information. You don't ask stupid questions. Boom. Done. So the court does not allow motions relating to discovery until after an informal discovery conference, as described below, is held. So that's fun. So Chille filed a discovery motion prior to the Rule 26F in violation of a standing order. That's kind of weird. That's kind of weird. If counsel's effort towards blah, 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 and then before the conference, counsel should prepare to deliver two chambers of brief no more than 2 pages in length, setting forth arguments for or against the requested discovery. So it's like a mini motion. In this case, plaintiff alleges he attempted in good faith to confer with defendants counsel to resolve this dispute, but has been unsuccessful. However, the only discussion between the undersigned counsel and plaintiff occurred via email on or about March 8th, 2023. In this exchange, the undersigned counsel sent plaintiff an email stating, attached to find the Lawrence County defendants for a set of written discovery. Hard copies are being mailed out today. If you have any questions or concerns, please let me know. Plaintiff responded by stating the following: I've noted your RFPs, but did you mean to send me the interrogatories, especially these ones? Sending interrogatories without leaving court before the 26F meeting is improper, and these questions are mostly requesting things that will be in my initial disclosures or for things wholly inappropriate, especially given my claims. Should I disregard these, or is there any reason I shouldn't file a motion for sanctions? I'm considering doing exactly that. Were you unaware that you're out of bounds? Now, I have talked, generally speaking, about a situation similar to this with two other counsel, and both are like, why not just respond to the discovery? Like, you're gonna have to respond anyway, sooner or later. Like, why not just respond? What? Why would you file this motion? I mean, are you just trying to be a dick? Are you trying to run the bill up? Like, why would you file this motion? That's generally speaking my understanding. If I had received this, I probably would have just responded to it. I would have probably asked for some concession, like, hey, you're asking for a lot, and we haven't had the 26F motion. Can you give me like 15 extra days to respond? I wasn't really in the discovery mode mindset. So if you can give me like an extra 15 days to respond, then yeah, I'll be happy to do it. And usually opposing counsel, if you throw them a bone, they'll throw you a bone, and then the next time you're up, you need something from them, they'll be more likely to give you what you want. So so anyway, they met and conferred, and he didn't comply with the rules, and now they say that it was not meant to cause annoyance, embarrassment, oppression, or undue burden or expense. He didn't really go into exactly why, but they go into, like, he doesn't actually say what damages he's looking for. And it's not unreasonable to request plaintiff's social security number. That is true, because until Chille says that there are no pending damages for loss of income or lost wages or anything like that, then I mean, he says he has injuries. He hasn't stated what those injuries are. So until he clarifies it, it's not lost wages. Then yeah, so his specifically social security number should be on the table. So if plaintiff is claiming loss of income, then his social security number is relevant. That's absolutely correct. So tax returns are not categorically privileged. Yeah. But the one issue that I still really have is they didn't just ask for Chille's social security number. They asked for the social security number of anyone who was helping him prepare his responses to discovery. And that is not an acceptable question. That is 100% not an acceptable question, because those people aren't parties and they're not claiming loss of income. Now, a lot of people have suggested to me that, well, the Chille says he's asking for attorney's fees, and they're going to want to know, like, who these people are, so they get positively identify him for attorney's fees. And that's a ridiculous argument, because Chille's not entitled to attorney fees, regardless of what he claims on his complaint, unless and until there's an attorney representing him, like actually substituted into the case. There has to be an attorney on a pleading in order for him to get attorney's fees. So it doesn't matter if an attorney is helping him prepare these things. That's number one. The only thing that matters is if there is an attorney's number up on the top of that fucking page, an attorney's bar number on the top of that page. The second thing is, you can't identify an attorney by his social security number. If I gave you my social security number, you would not be able to go to the State Bar website and put in my social security number to figure out if I am a licensed practicing attorney. All you would need is my name, and that's not protected. So none of this makes sense. None of it makes sense. And it is not likely to lead to relevant information. You could disagree with me all you want, but the social security number of the people who are helping him prepare the responses to discovery are completely not relevant. So that is their motion. They have supplied the actual documents they sent, which is awesome. But again, we already had those. And where's the request? Interrogatory number 2. See, set forth the full name, address, and social security number of all persons assisting you in answering these interrogatories. Like, if there's a secretary helping him type these things up, like all of a sudden he has to get her social security number and give it up. I don't think so. All right, so let's make this bigger. Boom, boom. All right, so then this is the other opposition. This is the city of Ironton's opposition. This is going to be the real opposition because, again, they have not withdrawn their request for discovery. So they're going to, first of all, they're going to go in, they're going to paint Chille in a bad light because, Chille takes his time to do everything. He responds to emails when he wants emails, but then you can't serve him by email, and he didn't receive these things even though his address hasn't changed, and so he should have received them. And basically, Chille's a big fat liar and a doo-doo head who's really trying to drag his feet and cause problems, and that's all these allegations in here. So this is the start of their conversations about the actual discovery issue. So first, hey, this is on the 8th, I think. Yeah, on the 8th. Hey, your discovery, I had your discovery due on the 5th, i.e. saying that, like, if you know something I don't know, like if there was some sort of extension granted, or if there were court holidays in there that extended this time period, or if there was something that extended the time period, if I maybe made a math error, let me know. But I had it set for May 5th. Can you let me know what's going on? This is a very polite email. I have no problem with it. In his motion, plaintiff's characterization of his response to the above email is as follows. Plaintiff responded essentially the same as to the other defense counsel, asking whether plaintiff should disregard the request in violation of federal rules, or if there's any reason why plaintiff shouldn't file a motion for sanctions. Plaintiff's actual response was, "My God, the ineptitude is staggering. You won the Dunce Cap of the Day award. They're not getting away with it, especially with lawyers like you. You're going to make sure they don't get away with wrongfully arresting me. Did you mean to send me interrogatories, especially these ones? Sending interrogatories without leaving the court before 26F conference is improper. And these questions are mostly requesting things that will be in my initial disclosures over things wholly inappropriate, especially given my claims. Should I disregard these, or is there any reason why I shouldn't file a motion for sanctions? I think I'm going to file a motion for sanctions. I won't rest until my good name is clear. Regards, Jose de Castro. Thank you, Chille de Castro." And then this was a response that we already read to Lawrence County. Thus, the only communication with defendants were ad hominem attacks and threats of sanctions. Now, in California, they take the good faith meet and confer requirements seriously. There's a case called Townsend that the courts cite a lot about. You have to be civil in your discovery issues, and the court can sanction people for not. So I'm sure that there are federal cases similarly on point about having to be civil, about counsel having to be civil. But anyway, notwithstanding his derogatory correspondence, the fact that Rule 26F2 indicates, and the fact that Rule 26F2 indicates that parties, including unrepresented parties, are jointly responsible for arranging the conference, Ironton defendants offered to confer with plaintiff and provide him with the Honorable Judge Barrett's 26F discovery plan. The Ironton defendant's response provided plaintiff with a roadmap to resolve the dispute, i.e. confer and draft a discovery plan. That's what reasonable people would do. That option clearly fell on deaf ears. Clearly fell on deaf ears, as the present motion was filed 6 days later. As noted previously, the court had to issue 4 show cause orders plaintiffs regarding the dispositive motions filed by defendants. Even then, plaintiff did not respond until the 11th hour to both sets of dispositive motions, and the case was even dismissed and closed. Yet, when the defendants make an attempt in good faith effort to move this case forward with a pro se party, plaintiff breaks his silence, curiously utilizes his email that does not want to be served through, threatens sanctions, and has the herein motion prepared within 6 days. Admittedly, it was a shit motion, and if I had spent 6 days preparing a motion, it would have been much nicer, and actually would have identified issues with the specific discovery requests that I'm seeking a protective order for. But, he's pro se, so what are you going to do? Plaintiff only utilizes the process when he believes it is advantageous to him. That is a correct statement of fact. Notwithstanding plaintiff's court's conduct in this matter, plaintiff's motion for a protective order specifically argues the information sought by the Ironton defendants is highly private and confidential information to embarrass and harass plaintiff specifically. Defendant's tax returns, social security numbers, and private medical records. Additionally, plaintiff argues the information sought is not proportional to the needs of this case and would invade his privacy. In support of plaintiff's position, he further contends his claims are unrelated to 1. Reduction in income, 2. Taxes paid, 3. Mental or emotional injury, 4. Physical injury, or 5. Loss of employment or wages. Also, plaintiff claims the information sought would be included in his initial disclosures. That is interesting. So, like, what damages does Chille have? I am just at a loss. The Arrington defendant's discovery requests are relevant and proportional to the needs of the case, yada, yada. All right. So Rule 26 governs protective orders. That is correct. So you have to actually demonstrate it with specificity. A party or person for whom discovery is sought may move for a protective order when the action is pending or as an alternative matters on matters related to a deposition. The motion must include a certification that they've moved in good faith, attempted to confer. And then furthermore, the moving party bears the burden of demonstrating the alleged harm identified in Rule 26C1 with a particular demonstration of fact as distinguished from stereotyped and conclusory statements. That was one of the issues that I had with Chille's. They've identified it too. He doesn't go into details. He doesn't actually say the things that he needs to say. He just throws out conclusory statements. He's not complied with the federal rules of civil procedure, this court's local rules, and Judge Barrett's standing orders. That is all correct. It mirrors the other one. So there you go. The Arrington defendant's first set of written discovery requests disputed or directed to plaintiff does not cause annoyance, embarrassment, oppressions, or undue burden or expense. Who knows? We haven't seen it. And then parties may obtain discovery regarding any matter not privileged as relevant to any party's claim or defense. For good cause, the court may order discovery of any matter relevant to the subject matters involved in the action. Relevant information need not be admissible at the trial if the discovery appears to be reasonably calculated to lead to the discovery of admissible evidence. That mirrors California's rule. So there you go. So, yeah. And it's quite broad. Great. Only allows courts to limit it if it's unreasonably cumulative, duplicative, can be obtained from other sources more convenient, less burdensome, or expensive. I don't know where else they could go to get Chille's social security number and tax returns, but okay. If the party seeking discovery had ample opportunity to obtain the information by discovery in the action, discovery hasn't started yet, and the proposed discovery is outside the scope permitted by Rule 26B1, and it's not. The mere assertion of a burden is not sufficient, but rather a successful motion for a protective order limiting discovery must specifically delineate how compliance with the discovery request will pose substantial and undue burden on the moving party. Yeah, he's not addressed any of those with the Arrington defendants. He hasn't even, nobody's given me the actual discovery request by the Arrington defendants, which is interesting. He presumably has issue with any request that would implicate his tax return, social security number, and private medical records. First addressing requests for plaintiff's tax return, social security number, plaintiff's amended complaint states that he is a videographer, vlogger, and civil rights activists, plural, who has been video recording, publishing his recordings on social media forums such as YouTube, Facebook, Instagram since 2020. Furthermore, the financial benefits of his postings have been an essential economic support for him. The amended complaint goes on to further allege that the Arrington defendants violated his constitutional rights by impeding his right to film public officials, conduct and record interviews, and other investigatory filming. Presumably, impeding his essential economic support would result in a loss of income. That is a valid assumption, and Chille's not smart enough to understand it. Because I assume that somebody else wrote his complaint, or he copied it from someone else. You know, like took someone else's complaint and just edited it to work for him, and so he doesn't understand why things are being pled in there that are being pled. By implication, his social security numbers, tax returns are relevant and subject to discovery. Blah blah blah. Yes, yes, yes. Medical records. He vaguely asserts several times throughout his amended complaint that he has suffered and continues to suffer injury therefrom. If plaintiff is not asserting any claims for physical, mental, or emotional damages, he need only respond accordingly. Yeah. If you just responded back to the discovery request, objection not relevant. Plaintiff isn't seeking any compensation for physical, mental, or emotional damages. Boom, that's it. That would tell under penalty of perjury the defense counsel everything they need to know. They would know that that's not being pursued, and it would also block him from recovering based on those at trial. So yeah, which is really stupid of Chille to do, but considering that this, I think he was arrested by the city of Ironton in like late 2021 or early 2022, and he hasn't gone to the doctor or produced any record of injury from Ironton. I don't suspect that he would recover anything. You need special damages as well as general damages. Pain and suffering is great, but you have to have some objective standard by which to measure the subjective pain and suffering standard against. And normally, your subjective pain and suffering is a multiple of your objective out-of-pocket expenses for medical expenses. So if you don't have any, if you have zero out-of-pocket medical expenses, then 0 times any number really is still 0. And so how much pain and suffering are you entitled to if you have absolutely no medical, mental, or emotional expenses that are like receipts? You get none. So enjoy. Notwithstanding the foregoing arguments, plaintiff is entitled to object providing his social security number, provide a partial social security number, object predicating on providing it during or off the record at a deposition. He can't object. They can push for it. I think they would get it, unless Chille says he's not seeking any damages for lost income, and that'd be phenomenal for the defendants. At that point, if Chille says like I'm not seeking any damages based on any of these things, then the one question that I would include as the defense is, how do you calculate your damages? What metric are you using to calculate your damages? And then I would go for summary judgment at that point. Like if he says it's all pain and suffering or something, like, okay, I would go for a summary judgment because there's no damages to base it on. And then there's the conclusion. And then we have exhibits. These are this is exhibit A, showing that they're nice and he's a dickhole. Oop, I didn't show it to you. Haha, share this tab instead. All right. So this is exhibit A. These are the emails showing that they were nice and he was not. All right. And now we're on to DeCastro versus Abrams. This is Google's motion to transfer to the Northern District of California, or in the alternative to dismiss. Now they underlined or in the alternative to dismiss. I think that's what they really want. If I was Abrams or if I was Peter, I would be asking my counsel to join in on Google's motion to say, we agree with Google's motion and we would like to be included on the motion to dismiss portion of Google's motion. That way the court would have the grounds to dismiss the case for Abrams and Peter without Abrams and Peter spending more money on their attorneys. No offense to their attorneys. And by the way, Kate Peter is still being represented by Wish, despite every allegation that she's made, that she's fired him. He is still her attorney of record. Nothing has changed there. Why would it? Kate Peter is a pillar of the community who never lies, and yet Wish is still her attorney, despite her multiple allegations to the contrary. So they've given us a table of contents. I think anything past 10 pages, you have to give a table of contents, if I remember correctly. Might be confusing California rules of court with the federal rules of court, but whatever. And then they have all the cases and statutes and rules and other citations. So they're submitting this motion. Chille is in the sole count of his amended complaint, alleges copyright infringement against Google and several other defendants. At least as to Google, the court need not take up plaintiff's glaring pleading features or the lack of merit in his claims because plaintiff filed suit in the wrong court. He did. Pursuant to the forum selection clause in YouTube's terms of service, an agreement he clearly entered into as a condition of using Google's YouTube services, plaintiff promised to pursue any federal litigation regarding the service exclusively in the Northern District of California. The Supreme Court has made clear that a valid forum selection clause should be given controlling weight in all but the most exceptional cases. An unbroken line of cases have held that YouTube's forum selection clause is valid and enforceable, and have applied it to transfer cases like this one, to the party's designated forum, the Northern District of California. There's Trump versus YouTube. There's Kiffle versus YouTube. There's Muhammad versus YouTube. There's Seaman versus YouTube. Seaman. And there is Songfi Inc. versus Google. This case is no different. It clearly arises from the YouTube service, charging Google with failing to take down content that plaintiff posted there, and then others copied. The terms of the agreement governing plaintiff's access to and use of the service are clear about where such a dispute belongs. All claims arising out of or relating to these terms or the YouTube service will be litigated exclusively in the federal or state courts of Santa Clara County, California, USA. Plaintiff's claims fall squarely within this mandatory forum selection clause. Accordingly, his choice of forum merits no weight. And the case against Google must be transferred to the Northern District of California. Even if this case was properly venued here, plaintiff's claims against Google cannot proceed on its merits. Most obviously, clearly, plaintiff has not satisfied a necessary condition to bringing a copyright infringement claim. He nowhere alleges that he registered any of the works that were infringed with the U.S. Copyright Office. That requires immediate dismissal because 17 U.S.C. Section 411A bars a copyright owner from suing for infringement until registration has been made. Ba-ba-da-bum! I wish I had said that months ago. Oh, wait, I did. And nowhere did Kate or Peter file any motion to dismiss based on that. Why? Or did they? Oh no, I think they finally got around to it. The very last one, I think Abrams' attorney did. I think he did. Yeah, he did. It's been so long. The court need go no further to dismiss the case. Beyond that, plaintiff's bare bones complaints are a little more than threadbare recitals of the elements of a cause of action, supported by mere conclusory statements, and fall well short of the requirement they must contain sufficient factual matter, accepted as true, to state a claim to relief that is plausible on its face. That is the Twombly-Iqbal Twickball. Finally, even if plaintiff managed to make out an infringement claim, the license he granted YouTube and others via YouTube's terms clearly covers and bars the claims against Google that he now tries to assert. For all of these reasons, the court should transfer this case to the Northern District of California, or, in the alternative, dismiss it for failure to state a claim. Factual and procedural background. I don't really care anything about any of that. DeCastro's claims. On September 2, 2022, DeCastro filed his original complaint solely against defendants Peter and Abrams, the individual defendants. That complaint asserts claims of defamation, counts 1 and 2, and intentional infliction of emotional distress, count 3, against individual defendants, but did not assert any claims against Google or any copyright infringement claims against anyone else. On November 16, 2022, plaintiff filed his first amended complaint, replacing the 3 counts of his original complaint with a new count 1 alleging copyright infringement against the individual defendants and unidentified John Does. Plaintiff styles his first amended complaint as a complete pleading in itself with no reference to his original claims, and it was recognized by the court as an amended complaint pursuant to Rule 15A1B of the Federal Rules of Civil Procedure. The first amended complaint thus supersedes the antecedent complaint, replacing the original complaint lock, stock, and barrel. That is correct. On December 2nd, 2022, plaintiff filed a supplemental complaint adding Google to the case, captioned as a defendant for the first time. It does not list any counts against Google or include a prayer of relief against Google, but the factual background section alleges that upon receiving notices of copyright infringement by plaintiff under 17 U.S.C. 512C3, YouTube failed to take down the infringing content on its service, having determined on multiple occasions that the purportedly infringing content is exempt from takedown under the DMCA due to copyright fair use. Although he attaches a list of URLs supposedly constituting his works, he does not allege that any of them have been registered with the Copyright Office. Plaintiff also does not identify which specific videos were infringed, where on YouTube those works were infringed, which, if any of those infringements became subject of notices to YouTube, or any other supporting facts explaining the nature of the infringement. Plaintiff wrongfully asserts the legal conclusion that YouTube's inaction was in violation of the DMCA and its standard technical measures because he notified YouTube that he had filed a court action. On April 24th, 2023, plaintiff filed a second supplemental complaint. The second supplemental complaint adds no allegations concerning conduct by YouTube, saying only that since the filing of the first amended complaint and the supplemental complaint, all defendants, including unknown ones, have committed additional copyright and DMCA violations against plaintiff. This time he includes a list of URLs where his supposed works were infringed, but he does not specify which URLs infringed which original works or provide any other details explaining the nature of the infringement. And once again, he fails to allege that any of these URLs infringed upon copyrighted works that he has registered with the Copyright Office. In sum, none of plaintiff's complaints identify any allegedly copyrighted works he actually owns and registered, except to vaguely assert the existence of over 800 videos, all of which he allegedly published to his YouTube channel at this URL and thus licensed to YouTube pursuant to the TOS. And despite having filed 4 complaints to date, he has still not identified which specific videos posted by which specific defendants infringe which specific works, let alone the nature of that infringement or whether those infringements concern any works registered with the Copyright Office. The court should transfer plaintiff's claims against Google to the Northern District of California. I don't really care about that. Let's just suffice it to say that it would. And then in the alternative, plaintiff's claims against Google should be dismissed. Plaintiff's claims against Google fail as a matter of law, come nowhere close to meeting pleading standards, and thus should be dismissed on the merits. The most obvious deficiency of plaintiff's claims is his failure to allege that any of his allegedly infringed works were registered with the Copyright Office before he filed suit, which alone requires dismissal. The Copyright Act and recent Supreme Court precedent leave no doubt that no action for infringement of the copyright in any United States work shall be instituted until registration of the copyright claim has been made in accordance with this title. And it goes on to further say that outside of statutory exceptions not applicable here, Section 411A bars copyright owner from suing for infringement until registration has been made. Where plaintiff did not register her copyright before filing suit, dismissal of the suit under Fourth Estate is proper. This Fourth Estate is the case. This pre-registration requirement is a bright line rule, and the burden is on plaintiffs to satisfy it. It is not surprising that the First Circuit has held that where a copyright complaint did not allege that registration had been obtained prior to suit, the complaint should be dismissed for lack of sufficiency of the complaint, with a valid citation to a First Circuit decision. The court need go no further. But wait, there's more. But there is more. Plaintiff's bare bones complaints come nowhere close to alleging plausible facts that give rise to an inference that infringement occurred. See Iqbal. To state a claim for copyright, plaintiff must plausibly allege 1. Ownership of a valid copyright, and 2. Copying of constituent elements of the work that are original. To establish the second of those elements, plaintiff must allege that the copying of the copyrighted material was so extensive that it rendered the infringing and copyrighted works substantially similar. Yet, as detailed above, plaintiff alleges nothing about the particular works being copied, or the nature of the supposed copying. Plaintiff alleges nothing about the particular works being copied, or the nature of the supposed copying. Plaintiff alleges nothing about the particular works being copied, or the nature of the supposed copying, beyond broad conclusory statements that reveal nothing of substance. Defendants publish content to YouTube that largely only copies my content. and also alleging defendant YouTube publishers have copied large portions of my copyrighted content on their YouTube channels. This is nowhere near enough to survive a motion to dismiss. See this case dismissing a complaint where plaintiff fails to make a prima facie, that means on its face, showing of direct copyright infringement by defendants. It is unclear whether plaintiff satisfied the pre-registration requirements. Plaintiff has not identified adequately the protected material or defendant's infringement of it, and the court is unable to determine whether there is any substantial similarity between the parties' materials. That seems pretty much on point. What I think might be interesting is who's the judge? That was Kelly. So that was not the same judge. But it would have been interesting if it was the same judge. All right. Plaintiff licenses videos to YouTube. Plaintiff's infringement claims against Google fail also because the only videos he claims were copied were videos he'd previously uploaded to YouTube, and thus had already been licensed to YouTube. It is a hallmark principle of copyright law that licensors may not sue licensees for copyright infringement. See this case holding that use of copyrighted work within the bounds of license is non-infringing. A copyright owner waives his right to sue for uses of copyrighted material that are authorized by a non-exclusive license. A defendant may raise a complete defense to a copyright infringement claim by presenting to the court with the license or sublicense on a motion to dismiss, and when presented with such a license that covers the allegedly infringing activity, the courts consistently dismiss claims of copyright infringement. In creating his YouTube channel, he agreed to the terms, yada yada, and then there we go. Matthew Gorman. There is an attorney who subbed in, Benjamin Margot. Of Wilson, Sonsini, Goodrich, and Rosati. Not really impressed with their website, but I'm sure they have plenty of money. Let's look at their people. Yeah. These are just partners. That's a lot of partners. Anyway, so there you go. There's that. And then there are, let's see, we've got some exhibits. These are the terms of service. Don't really care. And then this is exhibit B. This is, oh yeah, Chille's a member of the partner program, which also reinforces it. He gave them a license. And then this gal says that yes, in fact, he had to have agreed to the terms of service. So there you go. All right. It was real fun. Let's see what kind of nonsense we have in the comments section now. Let's see what kind of nonsense we have in the comment section. All right. So happy Saturday. You're welcome. I am not a troll, sir. I identify as a chicken. Hiya, long time no see. How do? Oh boy, pseudo law and family law and the UCCJEA, a fun combination. The UCCJEA is the Uniform Child Custody Jurisdiction Enforcement Act. I don't know. I didn't know we were going to talk about the UCCJEA. Basically, it's a federal requirement that states comply with the UCCJEA, so that like parties can't like take the kid to another state to just to get the kid out of the jurisdiction of the state that the action was originally filed in. Um, I don't know. Hi, hello. As a former foster parent, before my husband died, I have stories. CPS is good, but also bad. Well, any organization that has people in it, and all organizations do, is going to have good and bad. I mean, there is no perfect. The giant flag makes it personal. Okay, how's Brokeback Mountain going? It's going pretty good. It's a lot of blur. Yeah, they, you know, when they're going out of their way to show you just the parts they want, they make it very clear that they want to show you just the parts they want. That says a lot. Wow, we can't even read it. So fine print. Dehydration from vomiting. Yeah, it was a vomiting thing. Pinch and zoom, and you could read. This isn't a touchscreen. This is a laptop that doesn't have touchscreen. I don't like touchscreen, generally speaking. Better from diarrhea. No, it was from vomiting. Cyclic vomiting syndrome or something like that. Baby could also be sick. It's some sort of a issue going on. Wife is a pediatrician, said it's a big red flag, but nothing that would be necessarily be worthy of a mandatory reporting. More information needed. Well, yeah, but there's something there, you know, like there's something there. That's all I'm saying. There is a statute in Idaho that allows children to be taken to shelter care, and if there is danger to the child's health, the, it doesn't say immediate danger in the statute, but it's basically if there's immediate danger, and dehydration is an immediate danger, they can take the kid. And yeah, so I mean, they were justified under the statute, at least as I read it. And I read a couple cases on it. I mean, I don't want to get too deep into the case law on it because I don't think that's really very interesting. But like the courts found that kids that were kept in a house with black mold, where mom was doing crack, but there's black molds, that was sufficient to take the kids away. They don't have to. They don't have to be like on their deathbed. I mean, it could just be a dangerous situation for the kids. Yep, more questions. High rights on. How is dehydration determined? I don't know. They don't give us the all the medical records, so I can't tell you. But a determination of dehydration was made. Babies are a hard stick. I will take your word for it. Babies are hard to get a vein on. Watch my kid go through that. Yeah, I mean, I'm just saying that it doesn't surprise me that it took them 4 sticks to get a IV into a dehydrated baby. How many missed doctor's appointment? One or more? That's a good question. They admitted to one. They admitted to one. How many more? Who knows? Is that true, Merb? Dehydrated veins are hard to get. That is true, Merb. Dehydrated veins are hard to get to. Yeah, that's my understanding. I don't think that requires a doctor to know. I mean, I've watched a few medical channels. I've started many IVs in my career, and starting one on a dehydrated person can be extremely difficult. Yeah. Godly Patriots, one, not onion. I wouldn't trust anything on that webpage. That is correct. That is correct, Merb. I was so dehydrated from acute food poisoning, it took 8 needle sticks to establish an IV on me in the ER. Yeah. Yep. Okay. Placing an IV on an infant can be difficult regardless. Oh, no, I've never missed any of my kids' doctor's appointments. People do. And just because you missed one doesn't mean that the kid's going to get taken away from you. The government is corrupt. Yes. Could it possibly be an overzealous reporter? Well, so there are lots and lots and lots. I mean, if you work in family law, you know that there are lots of unfounded reports made to CPS. Lots of unfounded reports made to CPS. The problem for believability comes when you have the report, and then you have the CPS investigation, and then you have the doctor saying, yes, take the kid away. And then you have the court, when it actually gets to court, the kid was taken away on the 11th. You have 48 hours, not counting the weekends and holidays. So the next in 48 hours was the 15th of I think March 2022. The court date was held. The court said, based on these allegations, it's sufficient to take the kid away. So you had a court make that determination. Could it have been an overzealous reporter? Sure. Except the court was like, yeah. You also have the DA. The DA had to be like, yeah, we're going to go ahead and try to take this away. So the DA had to have looked at it and been like, there's something here. We need to do something legally. And, a lot of the times, the goal of CPS, the goal of these cases is not to take the kid away forever. The goal of that is, generally speaking, to get the parents into compliance, to get the parents to actually take care of the kid. That is the number one thing that CPS is trying to do, that the state is trying to do. There's a lot of cost associated with taking kids away, that they have to pay foster parents. I mean, there's a lot of costs associated with this. These legal proceedings aren't cheap. They have to pay for the DA or the public defender and the DA and all these things. It's not the goal of the state to take the kids away. It's the goal of the state to reunite the kids with the parents in a functioning home. And that's what ended up happening. Double hard. I've had to start many scalp IVs on infants due to dehydration. Another thing is they show you images of the child, the baby, sleeping peacefully, close up, high resolution images that show the skin was dry and like flaking a little bit, and they contrast it with videos of the kid happy, awake, playing previously, like a few days before. And I mean, there's a world of difference between a sleeping baby, a high resolution photograph, and some dry skin, compared to, you can't see dry skin on a video, especially if the baby's moving around. And he tries really hard to make his case, but it just becomes really apparent that he's making a case. He's not actually presenting the facts. He's making a case. How is it that we are suddenly making assumptions of medical conditions based on a fascist conspiracy theory website? Okay. I bet that broke your heart. Poor baby. Yes. Hey, I thought this was over with and he lost it. I believe they got the child back. Merb, the auditors kin our rights, whatever. I woke up feeling like a godly patriot today. Thanks. Okay. Killing. It was difficult, and keeping parents calm through the process is key just as much as the baby. And that's another thing. Like, the cops lied to get the kid away. Oh, we just want to have the EMT look at the kid and we'll give him back, right? Cops, guess what? Cops can lie. And they lie for a reason. They lie because they want that exchange to go as smoothly as possible. They don't want the kid to get upset. They don't want mom to like try to grab the baby and run or otherwise place the baby in danger. So they want to get that kid willingly handed over to the EMTs in a safe, calm manner before they drop the bomb that, by the way, you're not getting the kid back. So yes, they lie, and they do it to protect the kid, to protect parent, to protect everybody. And I don't fault them for it. That's watching Deborah and Chille celebrating her guilty verdict in all charges like she won something is hilarious. Yeah. She might be getting an appeal. I don't know. I haven't checked up on her appeal. It was a shit appeal. She's going to lose, but whatever. The word malnourished was used by the news in describing the baby. Yes, I saw that. But so the problem with a lot of this stuff is that the records are sealed. You cannot see anything about that baby's medical history, about the court proceeding. You can't see shit on it, like zero. The CPS can't make a statement. The doctors can't make a statement. Nobody can make a statement to you. I mean, so anything that is in the news, I wouldn't necessarily trust any more than what it was on that guy's website, because the news doesn't have access to it. No one has access to that court proceeding. And the grandpa made a big deal about how, you're supposed to have a public trial, but you don't get that for children. I don't know of any state that gives that for children. Hope you and the rest of the chickens are having a wonderful weekend. Bakak. Why is he seeking a protective order? He won't ever show up in Ohio because he will get arrested. The protective order is just basically, generally speaking, a protective order is where the court will say you don't have to answer these specific questions. Now, he was misusing it. I don't think the court would have actually technically granted the protective order, but the court might have fashioned some sort of order like you don't have to answer these questions until like 30 days after the 26F conference, which isn't technically a protective order, but whatever. Thank you. And well, let me get my pants off and get comfortable. You should have had your pants off to start with. Old McMurd had a farm. Lowell, rock out with your cock out. Chille will ask dumb questions. Absolutely, he'll ask dumb questions. And I would fully anticipate that they will either answer them or object to them, and they won't seek a protective order. Chille's all about asking stupid questions. Will 34th Street Gang eventually give an opinion on the Karen Reed murder case in Massachusetts? I'm not familiar with it, so probably not. Chille has no choice but to ask stupid questions. Chille's getting boring. I'm looking for a new favorite show. Well, I'm sure that Discovery is going to kill the Chille show. Once he figures out that there's a fuck ton of work in a lawsuit, I think Discovery is going to be a very rude awakening for our boy Chille. I think he was hoping to get out of it well before Discovery, and get ready for the pain. Hope you're doing well. Lawrence County is corrupt, but Chille needs to stop with all the lawsuits. Probably. Most governmental organizations have at least some level of corruption in them. I'm a few minutes behind, but when I had mono and was dehydrated to the point where my limbs were going numb, it took them 20 minutes to find a vein that wouldn't collapse, and they put a needle in my hands. Yep. So I had to go into my elbow for the IV. Well done on the WNN video. Oh, yeah, I saw that video. How does anybody watch that slobbering idiot, WNN? Like, the guy's he's a documented liar. What fucking just was hilarious was that Kate called him out on his lies about the FBI call. And then next thing you know, him and Kate were like best buddies once I started making statements about the way Kate was acting like Chille. All of a sudden her and WNN are best buddies, and water under the bridge, right? Chille needs to file a lawsuit to grift and try to hit the jackpot. on Karen Reed killed her husband while in a drunk stupor and backed into him. He died in the snow from being cold. Karen Reed killed her husband while in a drunk stupor and backed into him. He died in the snow from being cold. I'm not really a big fan of police, but I've decided to be reasonable and avoid them at all times when possible. Generally don't break the law instead of running up to them, screaming at them. That is an excellent strategy. Police, it's dangerous to interact with the police. They are armed and they feel like they can use their weaponry at a whim. And lots of people get killed from police every year. And whether or not it's justified is a different story. Best practice, don't hang out with dangerous people. But to each his own. Thank you. I have a few going back 4 to 5 months. It is when proving they don't exist. Okay. I will look them up. Because question mark, that's what the government says. Question mark, the evidence says otherwise. By the way, girlfriend, not wife. But he's a constitutional law scholar. Isn't Maria the same level as you? No. I'm really starting to get into the Joey Amico show. That guy is a real lol cow. That's Vegas Valley Cop Watch or something. He's something. Unforted federal counts are canceling that show in 3 months. All the civil lawsuits I have filed where I represent myself and won, I was awarded my out-of-pocket costs only, such as filing fees and photocopying fees. Well, I'm going to press X to doubt that you are a master litigator. But yes, you would only be entitled to costs, not fees. Because for this to be a conspiracy, it's at least 60 people big. Occam's razor, my dude, she backed into him. He was knocked out, and a plow came by and tossed him into the yard. Explains the cuts and damage to him. Those autopsy photos are not showing dog bites. How is it so sunny and bright at the Godly Patriot Merb's house when it's gloomy and cloudy here by the Rose Bowl. Magic, my dude. Snowplow, when did the plow come into the story? Chille's writing lawsuits for other auditors now. Well, they're gonna have the exact same results that Chille's getting. So there you go. Ha, Chille's so hyperbolic. Floyd needs the money to pay for his 40 wives. Did he actually marry one of those foreign ladies? Good for him, you know. Uh, I don't anticipate Floyd's going to get rich off this, but good luck to him. Karen Reed definitely killed her boyfriend. The evidence is overwhelming. So we have one guy saying it was accident, one guy saying it was murder, and I don't know. Conspiracy? No. Towing the blue line. I think it'd be TOEIAG, like putting your toe on the blue line. Cyrax is mentally challenged. Chille is just stupid. Cyrax is back on YouTube. I don't follow that. I'm not the lol cow guy. I like legal pleadings and things like that. I like cases and legal analysis. Cy is an example of why it's a bad idea for cousins, siblings to breed. No, screw the cops. They're too stupid to carry out something like that. To carry out something that elaborate. Occam's razor, my dude. This isn't a planted gun or crack. It's a murder conspiracy. They aren't capable. He's just a troll. Is it true that Cyrax's father and brother are the same person? He does not have any damages along with the other hundreds of lawsuits he filed. That is correct. I've never understood calling people trolls or saying they're trolling just for having a different opinion or perspective on the topic. Was thinking the same. Writes on. And to be honest with you, I like Writes on. Like, I don't call him a troll. He has a different outlook on things, some things than I do, but that doesn't make his opinion any less valid. Yes, the state will make its case according to the dirty state cop who wrote the report, the off-duty state cop who was called once again by his buddy, Mr. Albert, to come fix his mess. Chille says he makes most of his money from his website, but I still can't believe anybody buys those stupid trifolds. All I hear is wah, wah, wah. Okay, well, the meth caused some mental issues. It is towing. Yep, there you go. No, his mental issues were pre-existing. So, I mean, I did buy a pet rock, but you get hit someone in the head with one of those things that had to use. Why has this lawsuit not been put in the circle file? All of these lawsuits have motions to dismiss pending. And they're waiting on a judge to make a ruling on those motions to dismiss or motions for summary judgment. So those would be why they have not yet been put in the circular file. They're circling the circular file. Potato tomato or potato tomato. I am late. Did Burb stand up by any chance? Not on camera. Pants or prison. That is true. Happy Saturday. No. Good morning. Unfortunately, not yet. Sounds like someone just laid an egg. Ooh, I really like this one. That's all Chille does. If you disagree, you're a troll, which is sad. I want an honest and open discussion with them. Honest and open discussions are nice. Hang loose, no pants. Grounds. I didn't hear any cocks. Is her attorney Wish, or did she get him through Wish? Is her attorney Wish, or did she get him through Wish? Kate's attorney is Wish. He is still her attorney. You will know when Kate's attorney is no longer Wish when either a new attorney substitutes in and replaces Wish, or when Wish files a motion to be relieved as counsel and that motion is granted. Those are the only two options, the only two possibilities. Until those happen, Wish is her attorney, and anything she says to the contrary is not grounded in reality. Chille lies much more than Kate does. I disagree, sir. The moral of the story is it's best to verify their sources when speaking to both of them. Absolutely. But Kate is not 100% grounded in the truth. I mean, she lies a lot, and she's been caught lying. Like everything you know, everything you need to know about Kate, you can sum up from the complaint that she prepared, that she mocked up to prove to Google that she had filed a federal copyright lawsuit against Turtle Boy. Like, that should tell you the level that she's willing to go to lie. There's a lot of little lies she tells, She is a casual liar. So what happened to the 60K? I'm sure that Wish got some, all, or most of it. Merb's cock is being discreet right now. I try. Morning, all. Clearly, Seaman versus YouTube. That was a sticky situation. Ah! My apologies if you addressed this already, but I'm curious what your opinion is of Chille refusing to call BB on a recorded line. Can the court mandate that BB not record any conversation? Yes, the court can do that, I would guess. But what's weird is that Chille records all of his phone calls. That's what's weird. And I believe, if I remember correctly, that Bacon, as part of his restraining order, is allowed to record any calls from Chille, but I could be wrong on that. Seaman versus Chille's lips. When did Seaman come before the court? Watching or waiting on the docket call for Pants versus Merb. Like, does Chille really have a case against BB regarding sanctions for the insistence of having a recorded line, or are they both just being petty at this point? I have not read anything on that. I don't think it's unreasonable, considering that Bacon has a restraining order against Chille, for Bacon to require that Chille talk to him on a recorded line. I don't think that's unreasonable. I think a court would probably, I haven't seen the arguments, I don't know all the circumstances, but I can see a good argument for allowing Bacon to record any conversations, any phone calls, any meet confers with DeCastro. Towing, to follow close behind leading something. No, if you tow a line, that means like everybody gets in a line, and if you tow the line, you are on that line. That's tow, TOE, towing. You're not pulling it. You're on it. You're towing the line. Very valid question. I think it's seminal to the situation. Looks like Google has some pretty good attorneys. Who would have figured? Yeah. Hi. I heard Seaman withdraw shortly after coming before the court, with the court holding the action was premature. Ooh, premature Seaman. No. It's not registered or behind a paywall. Typo. Chille said the state had hired inexperienced attorneys for their civil rights lawsuit. Chille said the state had hired inexperienced attorneys for the civil rights lawsuit. He said they were easy to outsmart. Is he talking about the city and the county? I don't think that those attorneys are inexperienced. I think they're inexperienced with Chille, but they're getting experience and they're figuring them out. Yeah. Toe the line. Follow the rules or obey the authority. Yes. Typo. Case dismissed. Oops, but he didn't ask Chat GPT. I don't understand why everybody wants to pretend that Chat GPT is writing these things. I don't think they are. You couldn't Chat GPT. Chille said the state has to hire attorneys. Chille said the state has to hire attorneys, and perhaps sometimes they do, but the state definitely has attorneys of its own, whether or not he or NNO files stupid lawsuits or not. My experience with dealing with government entities is that quite often they will hire outside attorneys to do the lawsuit. So, like I've got a couple lawsuits against the city of Sacramento. They are using their in-house counsel, but in a lawsuit against Rockland, the city of Rockland, they hired outside counsel. Sierra County hires outside counsel. It's fairly common practice. I think I hear the Cox now. Chat GPT. Your guys' burns against Chille are really weak. I just wanted to let you know that. Like, they're not funny and they're really weak. Oh, I see what you're saying, but now I'm using the word toe to mean something else. Okay. I was like pretending to be retarded. I work for the legal department of a governmental entity. They would have shredded Chille already. Well, you're a bit biased then, aren't you? I have So, in my experience, and you are free to disagree. In my experience, I have worked with multiple attorneys that have like semi-retired from state practice, from working for the state, and they were not exceptional. In fact, one of them was a really shit attorney, like a terrible attorney. Um, so there's that. And I've never specifically been impressed with people who are working for state, county, and city governments as attorneys. And there's two kinds of people in the world. There's the kind of people who are going to go get a job that's safe, where they're not really getting paid to perform. Um, they just have a steady paycheck. It doesn't really matter what they do, how well they do it, or anything like that. Um, they're going to get paid the same amount. And people who go into private practice, where you have to actually perform well, where you're judged based on your results. And like if you're on contingency, you're really judged based on your results. So I don't. A lot of attorneys like to go into the working for state, federal, local governments, etc., because it's safe, because they don't have to fight for their meals, because it's low pressure kind of job. So I haven't been particularly impressed. The grammatical errors in the documents are very disappointing. It's easy to make mistakes, but not highly professional. I if there's a bunch of egregious errors, then I might get a little judgy. But just one or two, I tried to let slip, because you know I I'm sure that my pleadings have multiple errors in them like that. It's just hard. It's just hard to do. Again, the best practice is, after you write it, read it out loud. If you stumble while you're reading out loud, go and fix that part. Write it again, or when you finish, read it out loud again. Keep doing that until you can get through it without stumbling, and it will be relatively error free. Can a client bypass their lawyer and file motions around the lawyer if the lawyer is not responding to requests? Probably not, because the 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 lawyer is representing you. You've seen issues with that with oh, what's that kid's name? Chauncey Hollingberry trying to get around his attorney, and the court essentially said, like, you can't do this anymore. Like, we've kind of let you get away with it once or twice, filing your own motions, but you can't do it. You have to go through your counsel. And yeah, James Freeman got the baby back. Sorry, I'm delayed. Yep. He got the baby back, or the attorney representing the parents um, managed to convince the court that the baby should go back, and or the parents took remedial steps to show that they are capable of having the baby and keeping the baby safe. Hope you're having a great weekend. Hope you're having a great weekend. Shiz, initial would be testing skin turgor test. Okay. Dehydration can be determined by blood work. Dehydration does cause trouble accessing veins. Yes. I love taking my daughter to the doctor. Always gets a lollipop. Good morning. Also, baby can become dehydrated in just a matter of hours. Right. Right. And a baby with cyclical or cyclic vomiting syndrome can probably become dehydrated even faster. Chille wants a case to be heard in Southern California District Court. Don't the terms of service require cases to be filed in a Northern California District Court? Yes. Sounds like Brett Kaloran. Okay. Good evening from Cambridge. Good evening to you. When will we know if Warden gets a new trial? His brief, his appellate brief, is due June 16th. So in less than a month, his appellate brief will be up. And then I would assume that the state gets a month or so to file its opposition brief. And then the court may make a ruling based on the briefs, or the court may set a hearing, an oral argument. So I would not anticipate Warden getting resolved until at least 2 months from now. Kate and WNN definitely aren't buddies. They both admittedly don't like each other. Well, that's funny. 100% facts, Merb. Yes, they do. Vanguard Merby. What does the patch on your hat represent? Uh, I got this hat with like a fire making kit. They gave a hat away with the kit, so I don't know. I don't know. It's a company logo for some company that makes it's like an ammunition can that they turned in like an emergency fire kit. Yeah. Nice hat, thank you. Merb, do you watch Nick Ricada? No. Thanks for the verification. Thank you. I saw a dog behind you. There's a couple back in there. Hey Merb, hear about Chille going after Dr. David on Chille video. Chille loves Sue everyone. Chille going after I don't know Dr. David. Sorry. I don't actually watch Chille. Kate lies constantly. I liked her 4 years ago when she called out Abrams, but she's friends with them now. Well, Abrams doesn't seem like a bad guy to be friends with, honestly. Like I don't know why anybody would have. I mean, you might disagree with him politically, but he doesn't seem like a bad dude to like generally. California is a all party state, yes. Yeah. Why don't YouTube boot him off the platform because he's biting the hand that feeds him? Because they probably don't care. Merb, will you ever monetize your channel? No. Wow, quite on topic, Merb. 2 cases about babies, one called Cyrus, the other called Chille. I see what you did there. I doubt that biting the hand that feeds him is in YouTube's terms of service. What's up, Flat Derp? It kind of is. They aren't there yet. YouTube will normally wait until it really hits them, just like when people like Valve have developers cause issues. I don't think Chille makes YouTube enough money for them to care, and I don't think this is costing YouTube enough money to care. Thank you so much for all you do. You're welcome. Does Warden have to serve the full 20-year term? I thought there was conditions for probation after a certain period of time. I'd have to look at it. Was counsel in Seaman Jack Offner? Deborah was found guilty, I'm aware, by a jury on all charges and sentenced to 30 days in jail. The judge said she has time served. Yeah, and her I don't know if her appeals were ever resolved. I haven't followed it. Anyway, that's it for today. Thanks for watching. Have a great Memorial Day weekend.